Good morning, everyone. This is Sasha Hodder. We're on the Hodlcast. Today is September 13th, and I just wanted to go through the United States versus Zavlaski case in a little bit of detail. It was reported on September 11th by a lot of news media outlets, Bloomberg in particular, that this case found the ICOs to be securities, and that's not the case. So I just wanted to kind of dispel some of the false information that was put out there by Bloomberg and many others. Like it's like Bloomberg put it out, they didn't even put the case's name, and then a bunch of other media places picked it up just using Bloomberg's story. So I had no idea news had such low standards until getting into this Bitcoin stuff, and it's crazy what gets reported. So what happened was the United States District Court of the Eastern District of New York, it was a gentleman named Judge Deary. He decided that the allegations that were laid out in the indictment, which was like the charges against the defendant who did the ICOs, if those charges were proved true with evidence, then there would be enough information for a reasonable jury to be able to decide whether or not the Diamond and REcoin ICOs were securities and whether or not the founder of those ICOs committed fraud by giving the investors false and materially misleading statements. So it wasn't decided. It just means it's able to go forward to trial. And what Zavlofsky is charged with is a conspiracy to commit securities fraud and securities fraud on both his ICOs, REcoin and Diamond. And he tried to dismiss the charges with really weak arguments. One, that the ICOs were currencies, that he was selling memberships and not selling, an investment product or investment contract. And secondly, that the securities laws are so unconstitutionally vague as they're applied that no person of ordinary intelligence could understand what they mean. And the securities laws can be kind of complex. I'll go through why both those arguments probably won't stand up. Interestingly, here all he sold was a pack of lies to people. Like he never made coins, he never actually delivered on anything. So the ICOs, the first company, REcoin, was an LLC based in Nevada, and it proposed doing real estate investments using smart contracts. And once the ICO was concluded, he just merged that into a Puerto Rican company that he called Diamond that was purporting to pool investments together to purchase and safely store diamonds in the United States. And he said the diamonds were fully insured. They said, unlike most cryptocurrency products, the real estate one, REcoin, was uniquely valuable because it was backed by domestic and international real estate investments, and it gave investors access to easy financial platform where people all over the world can convert their savings into real estate-backed currency for the potential of high returns to protect their earnings from inflation. And he also said, REcoin had some of the highest potential return. Also in the REcoin white paper, it was listed that investors could change their money into a more stable and secure investment than cryptocurrency or fiat, which was real estate. So, and they said real estate always grows in value. REcoin was led by an experienced team of brokers, lawyers, developers. Proceeds were invested into global real estate based on sound investment strategies. So turned out, they hadn't hired any professional help like brokers or lawyers or developers, and the proceeds, went into his pocket, not into global real estate. And then likewise with the Diamond white paper, they said the Diamond was intended to indefinitely prolong the lifespan and development to increase liquidity, visibility, and enhance credibility worldwide. I guess that meant the credibility of diamonds. I'm not 100% sure what they meant, but it certainly sounds, like they're saying it's going to be good. They also said it's going to be 10 to 15% annual growth, which, as we know, is a no-no in these kind of ICO things. So surprise, surprise, they never bought any real estate or diamonds. They never hired any staff and they never developed anything. So the indictment was presented to a grand jury. The trial was called, sorry, I gotta put my sunglasses on. Trying to get a more interesting background, but it is hot as balls out here today. It's probably like 100 degrees and it's only like 8:30 in the morning. Okay, so the indictment, it was presented to a grand jury and a trial was called, and it was determined that no matter what label they used for the ICO, Congress proposes to enact securities laws to regulate the investments. And it doesn't matter what form they're made in or what they're called. So sorry, I feel like I look silly with this class. Anyway, so yeah, so they basically quoted this 1990s case with that, saying that, the purpose in the securities laws is to regulate investments. And it's that whole thing, if you're gonna can't call a cat a dog or a cat a duck or whatever the saying is, if these are securities, call them securities. But if you think you're going to call your securities a token and get away with it, that's not the case. They look at the actual substance over form. And the judge said in this, the core nature of his alleged criminal endeavors charges a straightforward scam, replete with common characteristics of many financial frauds. So I thought Tone Bays would like that because it's just, it's the word that all of his like live stream people bet on. How many times is Tone going to say scam? And here the judge even said scam. And the order also states that the questions of whether coins were security, currency, or financial instruments altogether is left to the jury, and unless the court is able to answer it as a matter of law at the close of evidence on trial. So then they kind of make a joke that nevertheless the parties engaged in a spirited debate, because they did go back and forth. Like the government put on that it was a security, and the defendant gave these horrible arguments, in my opinion, that it wasn't a security. So we'll look at those a little bit. Zavlaski argued that I think I did mention this earlier, but they said the government didn't have enforcement power criminally or civilly because it was decided that tokens are not securities. Well, that has certainly not been decided. Congress, while they've yet to decide what an investment contract is, the Howey test is the basis for the factual inquiry. And the question is whether the elements of a profit-seeking business venture are sufficiently alleged in the indictment, and that if those things that are alleged are proven at trial, that a jury could reasonably come to the conclusion that the investors gave capital, that they were aiming to share in the earnings and profits, and that the promoters managed or controlled or operated the enterprise. I don't think that's going to be a hard thing to find here on these facts. So unless they can prove the facts are wrong, we're in for a security finding, unless they plead this thing out and don't go to trial. So we'll go through the three Howey prongs that were listed. So the investment of money. Zavlaski and his legal defense team said that REcoin and Diamond did not involve an investment of money, rather they just sold memberships. The order cited 4 securities law cases that all said cash is not the only form of contribution or investment that will create an investment contract. The investment may take the form of goods or services or the exchange of value. So it's saying that since Howey, like a long time ago, they've really expanded what that investment of money can be. So it can be your time. And we saw that recently in the airdrop case, Tomahawk, where they said that even though the coins were airdropped or used, I think they were more referring to coins used in a bounty program. So they were given to people in exchange for services like marketing services on Twitter, that kind of stuff, finding bugs. That's all using the person's time, which is, time is money. So that's an investment of money. That's I think it's really broad, but that's how, that's what the case law has come up with. The second prong is the common enterprise. So to allege a common enterprise, the indictment has to establish that a certain level of commonality existed between the investors in REcoin and Diamond. Um, the Second Circuit has, so the way courts are set up, each circuit has its own kind of way that it's developed the law, and the Second Circuit has a big body of law looking at horizontal commonality, and the Second Circuit is New York, just in case. So, we're dealing with all of Wall Street and a lot of businesses in the Second Circuit, so it's a very well developed circuit of law. But it says that horizontal commonality is enough to establish this prong of the Howey test, and that's basically when investors pool their investments or their assets and they expect some kind of pro rata distribution of profits. So it's kind of like people expecting dividends on their stocks. And here, I think REcoin and Diamond, they required people to pool their money together to invest in either real estate or diamonds. So a reasonable jury can probably find that one. And then the third prong, they have the expectation of profits. So here, if the alleged facts are proven, a reasonable jury can find that the investors, like, they gave their money expecting that the company would generate a profit for them through the pooled investments into real estate and diamonds. And they even were told such, blatant, you're going to get 10 to 15% profit here. So that one's not going to be hard to find either. And then the second argument was this due process analysis or argument saying that the securities laws are too vague to give ordinary people fair notice, and it invites arbitrary enforcement. So Judge Ziri stated that the indictment against Zavlowski, it satisfies both prongs that it has to be, not vague and unconstitutional. So it's understandable by a person of ordinary intelligence, and that the Howey test definition makes it reasonably clear that the charged conduct was criminal. And he made a kind of funny comment I thought it was funny. He said, for over 70 years, this test has provided guidance to courts and litigants as to the definition of an investment contract under the securities laws. So, if I just thought it was funny. He's saying, okay, we have this case law that's existed for 70 years. It's been used thousands of times in other cases. So it was kind of pointing out the absurdity to say that Howey test is unconstitutionally vague. If it survived 70 years of case law, it obviously isn't vague. So it was also noted that Zavlowski was warned by the SEC specifically that crypto could be considered securities in the Dow report and in multiple other public statements. And the SEC actually submitted a letter in this case too, just saying that they thought these were securities. It was just a short letter since they were investigating them as well. So this was for the criminal case. So in conclusion, this is just going to proceed to trial. It doesn't mean anything today of whether or not all ICOs are securities, but if it does, it's very similar to the central litigation. So if a jury does find out that these, or does decide that these are securities, and given the egregious nature of this fact pattern, it's not going to be a hard thing for a jury to come to that conclusion. Then we'll have it on the books in New York. All right. Thanks, everyone. Have a great day.